whatever.
Good evening and welcome to Collecting from the Dead.
So 366.2 is the statute of limitations you should all be aware of and afraid of. Because if you don't file something by the 1 year statute of limitation, you are barred. And so looking at 366.2 and also 366.3, if not told, these statutes bar suit on a liability of a decedent unless you file something before the first anniversary of the decedent's death.
If I can just add one little thing. I think one thing I find a lot of people get confused about, including the judges, I think, to some degree, is that there are really two statutes of limitation. And so it's really easy to, Jeff has talked about one so far, but I think it's easy to jumble those together or conflate them, and to remember that we've got this Code of Civil Procedure statutes, and then we've also got the separate probate code statutes. So as we go through this, keep in mind that we've got two separate bars, each of which are going to have to be met.
So let's talk about 366.3 for a minute. That applies to a different type of actions, to actions to enforce a promise or agreement for distribution from an estate or trust or under any other instrument. Whether the promise or agreement was oral or written, the action must be filed within 1 year after the date of death, and any other limitations periods that would have been applicable, they do not apply.
The other big example I see of the 366.3 cases are people who are living in the family house or the decedent's home. And so somebody may have been promised, when I pass, you'll get the house. The person's been living there for a long time, maybe decades. And
it is the essence of what a trustee's duty is under the revocable trust, and how you will operate that, both from the creditor's point of view and the estate's point of view. I, for one, would err on the side of opening a probate for my creditor, because I don't want to fall off that cliff and get told that my statute's run and I've got no claim. So I do it that way in order to try to force the trustee or the estate or the family to defend the probate. And maybe they'll come in and maybe they'll file their own, or maybe they'll object to my creditor being named as the trust executor.
I think one of the themes I want to share tonight is really that this is not to get people scared, but I think this is an area where the courts come down pretty hard on the deadlines, as we'll talk about, and that the judicial discretion is fairly limited, if any. And so I think what Jeff is saying is, in terms of hesitating perhaps about giving advice, is that you really need to think through these situations because the rules are complicated. Particular facts may change the analysis, and as we'll talk about, the cases come down pretty hard if you get it wrong. So we'll talk through these issues, but I think erring on the side of caution is good advice.